Facebook post say?
That bitch was tied up.
Good. Great. Do you have any plans?
Hello, everyone. It's Excited Utterance here. Hello. And it is a little bit early for us today. We're starting half an hour early. The reason we're doing that is it's a special day for MLSN and for the Zachariah Anderson movement, because later on today, there will be a stream over on David's channel, and that will be all about something we've never seen before, Sadie Beecham's interrogation. And I'm a bit nervous to watch that. But before that, we are going to have a little bit of fun, kind of, and we're going to have a look into the appellant document or appellant brief for Nick Godejohn. Now, if you are new to this, which I'm sure you're not because we've been running this for a few weeks now, and it's the second last in the series, Nick Godejohn is the boyfriend of Gypsy Rose, who did the stabby, apparently, of Dee Dee Blanchard. And hello, everyone. Oh, we have Bifrons in the chat. Hello, Bifrons. Good to see you. We have Half Irish. We have Dizzy. Hey, Dizzy. So I almost called you Dee Dee. You would have been come back from the second line. Yeah. And we have John come in. Hello. How's your baby going? You got no alert? I don't know why. All right, and let's bring everybody onto the stage. Hey. Hello to all of my guests. Well, one guest. We have Mr. Branca. The other guys, they're always here.
Yeah.
Hey.
Oh, I see.
Great to have you guys here. Hello, Andrew. Well, you're almost part of the furniture these days, aren't you? You could have just about be my second co-host.
Yeah.
Couldn't you? It's so great to have you, though. I love having you on panel.
A pleasure to be here.
Love having you here. Thank you. Well, today we're actually going to use you for some legal stuff, rather than
not just jokes.
Yeah.
Well, I mean, jokes are good.
There'll probably be some of those.
Well, I'm sure there'll be some of those. Great to have you here. Dali, how are you?
Wonderful.
Good. And Mr. Vilhammer, how are you?
I'm alive. My brain doesn't really feel like it, but
I am alive. Very good. Hey, John. And hello, Daniel D. Thankfully, I get Discord notifications. Well, David should have had a Discord notification. There's no reason why you shouldn't have. Sal better get ready to pay child support for this one. Do you want to, Andrew, do you know about the surrogate baby?
His name is Kidney Stone after me. It's really
yeah.
flattering.
Yeah, John Common has a kidney stone and he's named it Sal.
Oh, kidney stones. That's tough.
Yeah.
Yeah. Because it's sodium and calcium. And the last one was called calcifer. And this one's called Sal. Because it's sodium. Yeah.
I get it.
We laughed at you got it. Yeah, lovely. Yeah. Anyway, so let's get into it. So we have the document. People. And here it is. I don't know whether you've had a chance to have a look at it, Mr. Branca. It's fine.
No, I have not. No.
Completely fine.
No.
So we'll start at the very beginning because it's a very good place to start. I have full Acrobat, so that means that I might accidentally look like I am editing it. But I have gone through and I've highlighted a few parts that could be of interest. Now, most of you guys who are on stream with us today have probably been here for at least some of the trial. So the trial happened in 2018. If you're new to the case, a little brief overview. Basically, what's happened is Mr. Godejohn, he has what's known as autism or potentially Asperger's syndrome. They are slightly different, but there was one witness, expert witness, that was brought to the stand by his public defenders, and let's just say he wasn't really much of an expert. He didn't bring much to the table in terms of his expert testimony, and that is part of the reason that this appellate motion is being brought forth. This is basically an appellate motion that is about ineffective defense counsel, and there was a hearing about a year ago that put forth another expert witness who says that actually, whilst this expert that was at the trial said that his autism was quite mild, and it does seem so on the surface, there's much more to it, and he was very unable to make his own decisions. Now, Gypsy Rose Blanchard, who I think we're all quite familiar with now, did a lot of manipulation, let's say, or she goaded him for 2 years, and that also did not come out at trial, and we will look at that in a moment. So what we have here is Missouri Court of Appeals, Southern District, Nicholas P. Godejohn, Appellant, State of Missouri, and it's an appeal to the Missouri Court of Appeals from the Circuit Court. Tyler P. Cole is his new attorney, and we'll just flick through this quickly. I've highlighted a few pieces to have a look at. All right, so Nicholas P. Godejohn, defendant, was convicted of first-degree murder and armed criminal action for the killing of CB. Now, CB being the victim, that is
Claudia.
Claudine.
Claudine, yeah, you go.
Claudine Blanchard. So she'll be referred to as as CB throughout the document. So it says defendant met victim's daughter GB. So that will be Gypsy Blanchard. Did I hear right? They both have P as the middle name. Who are you talking about? P. Sorry,
Nicholas, Paul, and Gypsy something.
Okay, maybe, not sure. So defendant met victim daughter through an internet dating site. Oops. I hate it when that happens. Okay, internet dating site in October 2012. They began a secret romantic relationship because victim controlled every aspect of GB's life. So victim being the mother, and would not let her have a boyfriend. GB told defendant that victim had forced her to pretend to be disabled to receive financial help and charity. By at least May 2014, defendant and GB had developed 3 different plans. The 3 different plans. Remember?
Mm-hmm.
A, C, and B.
Yes.
Because they went in the wrong order. To try and get GB away from victim so they could be
fair
together.
They had to put him in the wrong order because he couldn't ejaculate. So therefore getting pregnant wasn't an option.
Well, there is that.
There is that. But also,
to be fair,
remember the lawyer couldn't get them the right way around. Also, the lawyer messed it up. That was his.
Do you ejaculate?
Yeah, correct. All right. So after a meeting between defendant and victim was unsuccessful, they decided on a plan that involved killing the victim. The meeting between the defendant and the victim. All right. Yeah. Between May 27 and June 10, 2015, defendant and GB sent each other numerous electronic messages about the plan. In these messages, GB asked defendant about the items he needed to commit the crime. He chose a knife from the crime and also told GB he wanted duct tape, the duct tape, to muffle the victim.
Mickey Mouse duct tape.
That's right. And he said he wanted it cut into pieces, right?
No, he wanted the full roll.
Oh, sorry.
He told her the full roll, and she cut them into pieces.
Yeah.
She cut them into pieces, which was
Woman
very
doesn't even
annoying.
listen.
Really, I mean, come on now. On the night of the crime, GB texted defendant and told him the victim had taken her sleeping pill. On June 10, 2015, at 2:07 in the morning, defendant texted GB informing her he had arrived at the house and telling her to get in the bathroom. After entering the home and making sure GB was in the bathroom, defendant waited a minute and thought about if he really wanted to do it. After the murder, defendant and GB went back to the defendant's home in Wisconsin. On June 14, 2015, authorities discovered victim's body laying on the bed. Victim died as a result of 14 stab wounds to her back. Only 4 of them went that deep. After her, that's right. After authorities identified defendant as suspect, AM, who's AM? That'd be the detective.
Maybe, yeah.
Of the county sheriff's office, Detective M, traveled to Wisconsin to interview defendant. Defendant waived his Miranda rights and made a statement in which he admitted killing victim. We remember that very clearly. He's like, yeah, okay, I'll admit it, I did it. Defendant was charged with first-degree murder and armed criminal action. Whilst he was awaiting for trial, defendant also made statements about the crime to journalists.
Jesus, dude.
I don't have those. If anyone's got those interviews, I'd love to see them. Both Dr. F for the defense. Okay, so this is important. Dr. F, if we remember who he is, he's the guy who was not well kept. He had bushy beard and things like that.
Yeah.
He was the guy who was sweating bullets. Yeah, that one. Right. So he was the one for the defense, and Dr. D for the state. So he
Dr.
was
D.
Dr. D. Yeah. Okay. So Dr. D for the state. So we had the 2 expert witnesses. Now, they examined defendant prior to trial and testified at the trial. Their testimony established that the defendant had autism spectrum disorder, so ASD, and an IQ on the low side of average. But he could read and graduated from high school. The jury found defendant guilty on both counts, and the trial court sentenced defendant to life in prison without parole for first-degree murder and concurrent term of 25 years in prison for armed criminal action. Okay, so in his first point, defendant argues the trial court abused its discretion in excluding proposed testimony of the defense's psychological expert, Dr. F. Okay, so hang on a minute. We have Dr. F. Dr. F was for the defense, right? So in his first point, so proposed testimony of the defense's psychological expert, Dr. F, regarding the effect defendant's ASD had on his ability to deliberate at the time of the offense. Right. So remember, when we were watching it, they didn't show us the legal arguments, right? So we didn't get to see the motions back and forth about what was allowed in and out. We did, unfortunately, all those arguments and things were cut out, yeah? Which is a bit of a shame. So apparently, there was some proposed testimony of the psychological expert regarding the effect defendant's ASD had on his ability to deliberate. Kind of important, right?
Yeah.
Yeah.
I would think to some degree.
Yeah. In his
there's
second
that whole
point,
premeditation you have to get over, but yeah.
it's kind of important, right? So, well, yes, that's true. There is that, but it has the ability to deliberate. In his second point, defendant argues the trial court abused its discretion when it permitted the state to call Dr. D in rebuttal because the examination of Dr. D conducted of the defendant prior to trial was not authorized under Rule 2506B. And then the footnote is omitted. I don't know why. With respect to both of these points, defendant argues he was prejudiced because his primary defense was lack of deliberation due to his ASD. Both of these claims fail because there was overwhelming evidence of deliberation. Yes, what you just said. Okay. So, yes, those things matter, but there was overwhelming evidence of deliberation prior.
Yeah.
So these things, yes, they're important, but no, they're not. Okay. So Amended motion claim A. Nicholas Godejohn was denied effective assistance of counsel, a fair trial, due process, and was subjected to cruel and unusual punishment in violation of his rights under the 5th, 6th, 8th, and 14th Amendments to the United States Constitution and Article 1, Sections 10, 18A, and 21 of the Missouri Constitution, in that his trial counsel failed to fully investigate and present evidence from a qualified neuropsychologist and specializing in autism spectrum disorder to support a diminished capacity defense. Counsel failed to exercise the customary skill and diligence that a reasonably competent attorney would have exercised under similar circumstances. Nicholas Godejohn was prejudiced as a result, in that had counsel not been ineffective, there is a reasonable probability that he would not have been convicted of a first-degree murder, an armed criminal action, and would not have been sentenced to life without probation and parole and 25 years. Okay, so can I have some thoughts on that, please? Because that's
that's not going anywhere.
Yeah.
No, you think?
No. So, I mean, appeals are for losers, right? I mean, appeals are for losers because you're only appealing if you lost a trial.
Yeah.
And the prospect of meaningful relief on appeal is something less than 1%. And meaningful relief typically means you get retried again. So you just go through the whole process all over again. But that's less than 1% of appeals.
Okay.
And for an appeal to be viable, there's really 3 things that need to have happened. One is whatever the claimed appeal is needs to have been preserved by objection at trial. If it's not preserved, the appellate courts generally don't want to look at it. There are exceptions to that, and ineffective assistance of counsel is one of those exceptions. So I'll circle back to that. But in general, it has to be preserved by appeal. Second, the appellate court has to agree this was a mistake. If they don't think it was a mistake, obviously it doesn't go anywhere. And third, the mistake has to matter. The verdict would have been different but for the mistake. Otherwise, it's called harmless error. Okay?
Sure.
Now, ineffective assistance of counsel is one of the most common appellate claims there are. Because everyone who's lost a trial thinks it's because their lawyer sucked, right? The lawyer must have screwed it up.
Yeah.
It can't be me. It can't be anything I did.
Yeah, because it's got to be the lawyer.
And it is one of the grounds for appeal that do not need to be preserved at trial, because it would be unreasonable to expect if the lawyer is incompetent, of course he didn't preserve his own incompetence at trial, right? So it's one of the most common grounds for appeal because you automatically get past that first hurdle that it was preserved. It doesn't have to be preserved, and it is of constitutional import. So you have in America, under our Constitution, the 6th Amendment, you have a constitutional right to effective assistance. And usually when your claims are based on constitutional matters, they generally don't need to be preserved by appeal. We just consider those rights to be so important that the courts will disregard the failure to preserve it at appeal. So he's fine there. The other question is, so it's the 2 remaining ones. One is, was there a mistake? Will the appellate court agree there was a mistake? And the mistake being that the trial counsel was constitutionally ineffective. And second, did the mistake matter? But I don't think we get past the first one, because the threshold for being ineffective in this context doesn't mean bad.
No.
Lots of lawyers are bad lawyers. They're not constitutionally ineffective. And it doesn't mean the lawyer made choices that you don't like. Lawyers are always making choices between different, strategic choices between different defenses or different arguments or different witnesses. And by the way, different experts. And the lawyer is not himself expected to be as knowledgeable in this subject matter as the expert he's calling. And when he presents an expert to the court, that expert has to be qualified by the court. So the court is recognizing this person as an expert in the subject matter. So if the court's done that and the court said, yep, I agree, this guy's an expert, how can it be ineffective for the trial lawyer to not have chosen the right person, an appropriate person, when even the court says it was an appropriate person? So I think the appellate court's simply going to say, look, this guy was an expert. He had qualifications. He had degrees and publications and whatever was presented to the court when they voir dired him. And that doesn't mean he's a genuine expert. He could be a dunce. but it would be enough that it would not be incompetence on the part of trial counsel to have accepted him as an expert.
Yeah,
Well,
because
what's happened?
it sounded like
Sorry.
the guy had experience as like with dealing with autism. It might not have been his specific like field of study, but he obviously had training when he was in school about it, and he's had experience with it in the field. So like, and again, that was going to be my question for you actually, and you already answered it. The court is the one that actually agreed that he is an expert. So I guess that
and what due process of law is supposed to grant you is not a perfect legal defense. It's the opportunity to present the legal defense.
Yes.
And of course, there were other experts that could have been called. And of course, there were other trial counsel that could have been retained. And lots of things could have been done differently. You don't get a reversal of your conviction because it all wasn't perfect. It just has to be good enough.
Yeah.
Yes. Well, hi, Cece. How's it going? Well, this next part says that the motion further alleged that once trial counsel elected to put forth a diminished capacity defense based on autism and Asperger's, any reasonable competent defense counsel would have investigated and presented evidence from a qualified neuropsychologist who had expertise and experience in the area of ASD and Asperger's syndrome. The motion alleged that Dr. F was not a specialist and did not have much practical experience with autism. So, okay. So they should have got someone else, right? Okay.
This is, I mean, look at that next sentence. The state argued that the defense expert was not qualified. Well, of course they argue that. That's what the state is always going to argue about. But what did the defense argue? The defense counter argued that their expert was qualified.
Yeah. Well, supposedly, but they were crap. Okay. Great. All right. So we'll move on a little bit. So the amended motion pointed out that unlike a specialist with practical experience, Dr. F could not explain how Mr. Godejohn's diagnosis would affect his ability to deliberate. On the other hand, a neuropsychologist with experience in autism would have explained to the jury that GB's manipulation of Mr. Godejohn over 2.5 years, combined with Mr. Godejohn's ASD and Asperger's, which would have negated Mr. Godejohn's ability to deliberate. A specialist would have explained that Mr. Godejohn's condition caused him to surrender his deliberation to GB's logic because he took her statements as literal facts. When she said that killing her mother was the only way they could be together and that it was up to him to rescue her, the amended motion pointed out that trial counsel would have been on notice to investigate and call such an expert after Dr. F's competency examination and a review of Mr. Godejohn's school and disability records.
See, but his own text go against that though. Like Nick's own text, like disqualified that.
I don't know. Okay, we're gonna flick forward a little bit because there's another expert's testimony, because there was a what do you call it, another hearing that came up that they're going to refer to. So just a moment. Okay, here we go. Co-counsel's testimony. What happened was there was a prior to Mr. Godejohn's case, lead counsel did not have much experience with ASD, but he learned more about the disorder during his representation. He learned more information about ASD from Dr. F, who also provided some reading materials on the subject. Lead counsel remembered that the state had objected to Dr. F testifying on the subject of diminished capacity, and it was not mentioned in Dr. F's report at November 30, 26 pre-trial hearing on whether Dr. F would be allowed to testify. We'll just go forward a little bit. Trial counsel remembered that the state called Dr. D in rebuttal to Dr. F. Dr. D found Mr. Godejohn's autism to be more mild, remember that, than Dr. F did.
Yeah.
Counsel did not consider hiring an expert in autism to counter Dr. F. If counsel had hired a neuropsychologist with experience in autism, he would have wanted to present that person to the jury. Lead counsel testified that he did not have a strategy reason for not hiring a neuropsychologist specializing in autism, other than the fact that counsel had Dr. F. So, co-counsel's testimony. Co-counsel AM AM, testified that he had significant role in representing Mr. Godejohn at the trial. He entered his appearance 2 years before trial. He handled the suppression motion, voir dire, opening statement, and the cross-examinations of many of the state's witnesses. AM did not have a role in hiring Dr. F, but he did work with him after the expert was hired. They hired Dr. F for a competency evaluation. Dr. F found Mr. Godejohn competent to stand trial and provided a report diagnosing him with ASD level 2, requiring substantial support.
I have a question for Andrew.
Yes.
Okay, Andrew. So if you were a defense attorney who had a client who made a confession after waiving your Miranda rights, made a confession of killing somebody, and then would you, if this person had autism, would you hire a neuropsychologist, or would you go out of your way to find somebody who's specializes in autism? Because your client confessed already, I guess is where my mind is going. Like, is there some type of legal thing where you're obligated to do that, or I'm just trying to understand what his argument is here.
I mean, I don't have expertise in any of these things, right? So I'd have to do my research and educate myself and try to make an informed decision. Is it possible I might end up choosing an expert who's suboptimal on the science? I suppose so.
It's possible.
Would that make me ineffective as counsel? I would suggest not. I mean, this is part of the noise in the system. Again, if they'd had a good outcome, they would be praising the defense expert's testimony, right? They had a bad outcome. And so now everyone wants to, with 2020 hindsight, revisit everything, which is what you do on appeal, and he's entitled to his appeal, and he's entitled to make these arguments. I just don't see them. If I were the appellate court, I think I would say this was a reasoned approach taken by the defense counsel. It's not like they failed to produce any expert. They didn't miss, like filing deadlines to get an expert qualified for the trial. I mean, that would clearly be ineffective assistance of counsel. This just feels to me like, listen, I would want a better defense than this, but there's cases where lawyers have fallen asleep in court during testimony, and it was not deemed to be ineffective assistance of counsel. So, and especially with the confessions, would it have mattered?
Yeah, exactly.
I mean, was it, even if this was error, was it harmless error? I mean, the little factual statement they had at the start was, he literally took time to deliberate, right, inside the house before killing her. I mean, and now they're arguing, well, he can't deliberate.
That's true.
Yeah, so that is true. If I were the appellate court, I'd say, listen, even if you should have picked a better expert, a more appropriate expert, it doesn't matter because it was error, perhaps, but it was harmless error.
Yeah, and I actually think the word that Nick himself used was deliberate.
He might have. Harvard has a question. Expert has an argument. Are there reviews for experts that can be found before selecting one, like Yelp, maybe? Is there Yelp for experts for their success rate in trials, Andrew?
Well, I mean, there are like telephone books for experts that lawyers can access. I've been listed in those books as an expert myself. Do they really help you qualify the expert? Like, is there a grade or a number score? No, there's nothing like that. It's just it's kind of like what their area of expertise is, how to contact them, and then when you contact them, they'll send you a CV, that kind of thing. And any kind of score of how effective they were at counsel. I mean, it almost doesn't make sense because you could be the best expert in the world, but if you take a lot of tough cases, you get a lot of convictions. I mean, criminal defense, conviction rates at trial are in excess of 90% in the U.S. So anytime you're an expert for the defense, you're going to have a very high rate of, failures at trial. Is that the expert's fault? I mean, that's just the nature of criminal defense.
No. All right. So what happened? I want to just ask you, what exactly is a post-conviction hearing and why would it occur, Andrew?
Well, there's lots of reasons it could occur. Basically, you're arguing that something went wrong. There was some inappropriate, some failure in due process.
Okay.
Maybe you didn't discover it until after the verdict. Maybe there's some pro forma things you need to object to. Like you might have a hearing, like an oddity of another oddity, a thing that makes these ineffective assistance of counsel claims unusual,
Mm.
is normally when you have an appeal, and it's a completely different issue. Say you're appealing because you think that evidence was excluded by the judge that should have been admitted by the judge, right? And that was a legal error on the part of the judge. The appellate court doesn't do any fact finding. They just look at transcripts of the trial. There's no witnesses in front of an appellate court. There's no evidence being presented because they're looking for technical legal error.
Yeah.
Except in ineffective assistance of counsel cases. So when there is a claim of ineffective assistance, and the appellate court, because one of the arguments might be, well, the defense lawyer had a strategic reason for not arguing that defense. He could have, but he had to choose between two, and he chose one, and that meant he couldn't logically pursue the other. Well, the appellant might say, no, he didn't have a strategic reason. It was just an oversight. And then the appellate court might actually call trial counsel in front of the appellate judges and say, explain to us what your reasoning was.
Right.
And making this call.
Do lawyers...
And there may have been post-conviction hearings here in that respect in front of the appellate court where they're actually generating new evidence, evidence that didn't exist before.
Yeah.
Very unusual for that to happen, except on ineffective assistance claims.
That's true. And I've seen those distant. They're
yeah.
amazing.
Do lawyers take it personally? Like if after conviction, another lawyer does raise
Only if you're
ineffective
Eric Bland.
assistance? Yeah. I mean, like, is it affect their reputation or?
Well, I mean, I would never take it personally. The client's entitled to the appeal. He's entitled to make that argument. It's maybe I did screw up. I mean, it's not for me to judge, right?
Okay.
I mean, that's up for other people to judge. There is a risk, of course, that if you're found to have been ineffective assistance, your malpractice insurance may be getting a phone call.
Oh, really?
Sure. Because you were found. I mean, that's what malpractice insurance is for, right?
Oh,
when lawyers screw up.
Be sued.
Oh, I
Sure.
see. I see.
Okay.
I see.
So then you
All
have
right.
to pay more.
So normally you would expect trial counsel to say, I wasn't ineffective. Because if they say, yeah, I wasn't effective, they're looking for a malpractice lawsuit.
Oh.
But, I mean, a lawyer who really has his client's best interest at heart, it's not uncommon to hear them provide testimony to the appellate court saying, yeah, I think I kind of was ineffective.
Well, I think
sometimes they even mean it.
Yeah. I think Gosney had that self-defense case that he got overturned. And the lawyer was ineffective, didn't.
And he said so. Defense counsel just said, nope, I screwed up.
Yeah.
Fair. And so they
And it
should.
was overturned.
If you
Good on him.
if you are wrong, it's good to admit you're wrong.
Yeah.
Now, the reason I asked about a post-conviction hearing is because there was one. And there was a neurodevelopmental, whatever it is, psychologist there. And his name was Dr. W. Dr. W had a lot of things to say. And it shed a whole different light on the developmental disorder that
Who was he hired
has.
by? Who paid him?
By the state, but Nick has a new defense attorney now hired by the state. I don't know how this occurs, but he does. So
No, you almost have to, right? I mean, if you're
Yeah.
claiming ineffective assistance, you're not keeping your trial lawyer.
Yeah.
Oh,
you can't go in there
absolutely.
with him writing the motion.
So yes, it's Tyler man who this document is written by. So Dr. W testified at post-conviction hearing that he is a pediatric neuropsychologist. He is not a forensic psychologist. His specialties are neurodevelopmental disorders such as autism, attention deficit disorder, obsessive compulsive disorder, and traumatic brain injuries. He is boarded in clinical psychology from American Board of Professional Psychology, and he's boarded in pediatric neuropsychology, from the American Board of Pediatric Neuropsychology. I'm going to have to get someone to take over in a minute. He's currently licensed in Florida and previously practiced in New York and New Jersey. I don't need to keep going with all that. Dr. W testified that developmental disorders have a I can't keep going with all that stuff. Let's go what he said about it.
Yeah, but I mean, now think about appellate court judges reading this, right? They're gonna have the same reaction, right? This is not law. This is not what they normally do.
Their eyes are going to gloss over.
Yep.
They hear it a million times.
Absolutely. Dr. W noted that Mr. Godejohn was isolated Mr. Godejohn reported that he gets frustrated with people and does not like crowds, which is typical for ASD.
Well,
Blah,
yeah,
blah,
neither do
blah.
I, but I don't go
Yeah,
out
okay. So I went and highlighted the bit that I thought was interesting. Dr. W testified that, as is typical with autistic people, Mr. Godejohn did not initiate, but was responding to the direction he was getting. Mr. Godejohn kept a journal between 2012 and 2015. Oh, I want that. Can we get that? That detailed his online relationship with
remind me.
GB. Yeah.
Remind me. I can contact the court.
Yes, please. Dr. W testified that the journal reflects Mr. Godejohn's ASD Asperger's because it mostly recounts facts instead of qualitative emotional content. He wrote goodnight to himself. Oh. Once he wrote, note to self, always keep GB close, for she is everything I ever wanted. He also noted that he and GB were becoming in sync with each other by their communication. The journal reflects that the relationship was all encompassing.
Wait, their menstrual
Mr.
cycles
Godejohn.
were syncing up?
But there's still issues with this, because like even his first sentence there, that he said
Yes.
that he follows direction, he doesn't give them. If you remember back to the text, you need to wear lipstick, you need to wear this, you need to shave your vajayjay, you need to shave your legs, you need to get me a knife, you need to get me this. Like, he's giving her direction. It's not the other way around. Granted, the idea was floated to him first, I guess, about the whole unaliving part, but he is giving her direction in their texts. So it's like, this is not true, what he's saying. It's just not true.
No.
But this is what you do as a lawyer, right? You take the facts that are most favorable to your client and you use those facts as the building blocks of a narrative, right? That's consistent with defense or relief or whatever it is that they're looking for. You're not obligated to share, to highlight the facts that are contrary to your narrative. That's why it's an adversarial process. So that's what they're doing here. They're just cherry picking the facts. And then the state will file a response, right?
Yeah.
With all these opposing facts. And then the appellate courts get to look at both. And then the comments, I am a little tired. I did 2 hours of jiu-jitsu today. So
Did you? Good for you. A Brazilian jiu-jitsu?
Yep.
Oh, do you do Brazilian? Oh, wow. Cool. Do you speak any Portuguese?
No.
No? Bom dia.
How to
Jiu-jitsu.
hurt people in the presence.
Yeah.
Fair enough. Hi, Bye Friends. How are you? Journals are recommended by therapists a lot. Yes, they are. I'm not sure if this journal was recommended by a therapist or whether it's just something he initiated. And hello, Anna Lizette. How are you? Another channel has a transcript, allegedly, of Nick communicating with a new girlfriend. Ooh, interesting. What is this other channel? Please avail me of this information.
Things.
It would be very good.
I need to contact the court and see what evidence I can get.
Yes, you do. You do, my friend. Hello, Puddingway. How are you? Good to see you here. And hey, Paralegal Liz. Awesome. And get vajazzled. Indeed, John Common. All right, so Dr. W reviewed the large number of videos. Oh, where are these videos? I've only seen one that GB sent to Mr. Godejohn and the ones that Mr. Godejohn sent back. Oh, God. Okay.
2 years worth.
Oh, wow. We could keep running this for a year.
Oh, boy.
Oh, no. and Veal and Dahlia are like, no, stop her. This is supposed to end tomorrow.
Maybe a
moving on to
special
something
edition.
else, people. Okay.
I can't imagine the shit that was said in those.
There's so much more. The video spanned from February 2013 to May 2016, May 26, 2015. Phoebe also communicated with Nick from her Demona Love Slave account.
Ooh.
In many videos, she was depicted in the role-playing personas as well as being naked and emtubating. They both look-
Intubating?
yeah, I can't say it. Sorry.
Making it and pleasing themselves.
Yeah,
Oh.
that. I'll take over someone.
They both took turns being dominant and submissive, or master and slave.
Oh, that's good.
GB told Mr. Godejohn when it was his turn to be master or slave. Dr. W found that videos from GB to Mr. Godejohn were instructional. Autistic people receive their information about the social requirements of relationships from the structure of videos rather than the outside world. Mr. Godejohn was receiving his information about the requirements for his social relationship from the video and not from anywhere else. The various persona were feeding Mr. Godejohn instructions. On the subject of love, for example, she instructed him, "If you love me, you will do this. If you love me, you will do that."
Oh, see? This.
And this is where the video that we showed the other night, where she walked around the bed and did the motion.
Oh, yeah,
yes.
That one. You remember that one, Andrew? You know.
Yeah. Yep.
You
Just
know.
keep in mind, lots of wives who want their husbands dead talk another dude into doing the killing. Happens all the time.
Yeah. Daddy Dom, for example, next week.
Oh yeah, we're starting another trial next week, and it's from last year, but it's so worth revisiting. Basically, it's
degenerate. That's why
it's so degenerate. But yeah, it is like that. It is a chick talking a dude into doing the stabby. So yes, hello, Anna Lizette. Fancy is going to be on our channel tomorrow. She is our guest for our finale of the series. So yes, make sure that you're there for that. That'll be awesome. I mean, don't blame Nick. Like my man's nether regions to be at least tamed. Oh, you like your man's nether regions to be at least tamed? Oh, that's fantastic. Anyway, what's the name of the next trial? Oh, this is the one that Dali is running, and that one is Texas versus Darren Lopez. I haven't quite decided what I'm going to run on this channel next. I think I'm actually going to run the Michael Peterson trial from quite a long time ago. It's the staircase case. But yes. But next week, we're going to be all Murdoch all the time. Actually, starting Friday. We're going to run the Koberger hearing on Friday, direct from the Ladar County Court. But we're also going to be crossing to our lady on the ground, who is at the Murdoch hearing. There's a one juror who was being questioned, so we're going to hear from her. But then Murdoch Monday, Tuesday, Wednesday, live. And then I'm going to need a break because I'm going to be up all night doing those because I'm in Australia and everything's upside down. After that, not quite sure. The Owl did it. Yes, Dizzy, the Owl did it. That one. Yeah, that one. Think about running that one. The Owl. Yes. What time is the Coburg hearing? At 9:30 a.m. Yeah, so on this channel, live. Yeah. And yes, I'll have open house. So anyone who wants to pop in can do. Andrew, there'll be a link for you if you're interested. You're interested in Coburger?
I don't know.
The Idaho guy.
Send me the link. I'll have to look into it.
The Idaho guy.
Idaho 4, the guy who allegedly stabulated the 4 people in the house while they were.
Oh, that case, right? Yeah. Well, it's certainly going to be dramatic. I haven't been following it closely. I just know that there's that people feel that the having chosen him as the defendant in this case may not be consistent with the facts and evidence is known.
Yeah,
I certainly feel that way. Lots of people feel that way, but lots of people are like, "Who cares? Let's just throw him in prison anyway, and potentially maybe stick the death penalty on him." So there you go. Yes, the 4 college girls, 3 college girls, and 1 dude actually.
Yes.
But yeah, they tore the house down already. Yes, they did. Okay, let's keep going. Would you like to continue, Bill?
Yes, Dr. W testified that the videos would affect Mr. Godejohn differently than a non-autistic person because the videos would totally define Nick's reality. There would not be a separate Nick out in the real world who could second guess his role playing. When he was in the role playing situations, he was totally there. This had to be a woman. He was totally there in an instructional setting where she laid the ground rules for how he was to relate to her. Dr. W found GB's videos to be fascinating because each role had its own set of rules. I can't say anything beyond that.
Oh, sorry. I was just chatting to Dizzy. Go on.
I just made it go away.
What do you need me to?
There we go. Nope. So if you had Demona, that was the master who was telling Nick that If you do what I want you to do, there'll be sex and there will be favors. If you don't, there'll be punishment. I'll take away GB. And then we have this later character introduced that basically shows up in a red wig and gives him instructions about how to hurt people, and that we're going to rob and steal and all the rest of the stuff. So to me, it was a very organized attempt to manipulate someone who didn't have the social judgment to really suspend belief. Dr. W testified that role-playing is the primary way that people with ASD used to build their relationships with others. The actual physical social interaction with people is too threatening and has too much information, so they can't process it. There are treatment programs that are based
Here we go.
role-playing games online. People like Nick are still autistic even when they are role-playing and losing themselves to the characters. After reviewing all the videos and messages between GB and Mr. Godejohn, Dr. W concluded that for the most part, it was a process of shaping Mr. Godejohn. It was a process of taking a person with a social deficit and shaping his behavior by sending instructions that if he loved her, he would do what all of her persona asked him to do.
Okay. Right. So if that's the case, does that make any difference?
I don't think so.
I don't see how.
I mean, because there's stuff that you have highlighted in the next paragraph that I think this is where stuff starts to fall apart.
Okay, go.
And this
People are talked into doing bad things all the time. That doesn't relieve them of criminal liability for the bad things.
Exactly.
Even if they're unable, like, medically and it can be proven that medically they were unable to do so.
So there's fair question, right? And the appellate court's likely to say, well, that was a question that should have been argued at trial. In fact, experts were brought in to talk about this at trial, and there's evidence so consistent with the state's argument of deliberation, including the defendant's own testimony, that all this is just theoretical.
Yeah. And the fact that even during the interrogation that they played, he had the skills to reason. It's not like he could not reason. Like, he had the ability to reason. He understood right from wrong. So even if he had a bit of a learning disability, right, and was a little behind the ball, like, he still has the ability to reason. It's not like he was under like some medically induced thing or something like that where he just was out of his mind. And they didn't claim that he was in psychosis or anything like that. It just But so Dr. W.
I mean, psychosis would have made a difference, obviously, but then we would have had an insanity defense.
Exactly. So
well, okay, because from what I can tell, the appeal is not about they're not going to try and get him off. They're trying to get him to
he was trying to get off.
No, second degree rather than first degree. So
they're trying to get him resentenced.
Yeah, they just want a lesser sentence.
They want that he's not culpable to first degree is the point. So anyway, could you read this next bit, or Dahlia, you want to take over?
You can go.
Okay. So Dr. W reviewed the text between GB and Mr. Godejohn from the night of the murder, and he found that there were a continuation of pattern where she gives him instructions. Conveniently here, they're leaving out the ones where he gave her instructions. 2 years of role-playing were a foundation for the events that took place on that night of the murder. They were part of programming a person with an autistic disorder to follow his instructions and engage in a behavior based on the fact that he would lose his object of fascination if he did not. In one video, GB went into her mother's bedroom and made a stabbing motion over the bed, which is the one that we watched.
Yes.
So, but like Andrew mentioned earlier, they're picking the facts that obviously make their case the best, but they're being very selective of that, because if they're mentioning the text, they clearly know that he was giving her instructions too.
Yeah. I found this one. I've never heard about this one before. You guys tell me whether or not it's
Ruby?
in any of the documentaries that I haven't seen.
Oh, yeah. So Ruby, we know about Ruby. So Ruby's introduction to her perfect man. So Ruby
Yeah.
was a new character that she introduced to Nick. So Ruby introduces herself as a sociopath. And so it's sort of like the culmination of the training, which again, to just remind everybody, is a behavior. If you love me, this is what you'll do. So Ruby was introduced to basically summarize that up in case there was any confusion if that was what Nick understood. So basically, she did have these multiple personalities that she created. There was Candy, which was the sexy whatever thing. Ruby was the criminal, kind of dangerous, evil one, as they called her. Or no, she was not the evil one. Sorry, the evil one was the Demona, whatever thing that she created.
Demona.
Yeah, there was a bunch of ones that she created of all these
Demona.
personalities. Yeah, they all had different wigs and all this stuff that she wore.
Wait, is it Mo?
There's like these were all the things that she did, and like she played along into it, but she also said that it was his idea, of course. But anyway,
she lied her ass off, but no one really
yeah.
seems to care about that. Hey Rexium. I was just CC is asking where the appeal document can be found. Dali, where did you grab that from?
The appeal document?
It was on Reddit, wasn't it? But you can get it from the court. But it's easier to just grab it off Reddit, probably.
Let me find it.
Yeah, cool. Cool. Keep going.
Yep. So Dr. W reviewed the interrogation videos from when Mr. Godejohn was first arrested. When Mr. Godejohn was waiting for detectives to arrive, he periodically mentioned that he was worried about Gypsy Rose. You go to the next one?
Oh, yep, sorry.
That he was still fixated on her at this time. And an autistic person will do anything to get to their fixation. So she eliminated alternatives until the only option left was what she wanted him to do. So this is talking about the plan A, B, and C. So when Mr. Godejohn arrived in Springfield on the night of the unaliving, it was his intention to talk to GB out of it and run away. He did not bring anything with him, and GB provided it all to him. And he tried to talk her out of it, but he was not able because she said there was no other option.
Yep.
Which just gets into the he said, she said stuff. So.
Yeah. Dr. W testified that when Mr. Godejohn was walking to the victim's room, he was having an argument with himself, which is typical of someone on the spectrum because they get overwhelmed and overstimulated. The argument in his head leads to autistic panic. When the autistic person does not think well, they panic when things get out of their control, and sometimes they are hospitalized for it. It's a typical reaction when they feel pressured by competing things or things outside of their control. So this is interesting because remember the whole person on my shoulder, evil side, good side thing that he kept going on about, which looked really bad, by the way. He shouldn't have kept talking about that, especially on the jail call. That looked bad.
Yeah. To me, this explains more why the reason he can't ejaculate than why he couldn't have not stabulated her.
Why? Explain why. Why do you think that has anything to do with the ejaculation thing, please?
because if you scroll just a smidge up, it says that so it's a typical reaction when they feel pressured by competing things or things that are outside of their control.
Okay.
So I'm going to take a guess, like he couldn't ejaculate when they were in the movie theater when she was dressed up like Cinderella. I'm guessing there is a reason for that because there's competing things going on in his mind and there's something that's outside of his control. And so I'm assuming
Cinderella turned on. Cinderella turned on. Okay. Yeah, I see that.
I mean,
popcorn smells.
Yeah, like, I mean, at the end, when after the stabulating was done, he couldn't ejaculate. She tried to give him a blowy, but he couldn't because it's like, the Sahara Desert in there. I understand. Like, I get it. His mind is somewhere else. He's like, why does this feel like sandpaper? I mean, I get it. I kind of feel for the guy, if I'm being honest. At least in that area.
Well, that's really well thought through. Are you you're a psychologist by any chance? Or
No, I'm not. I'm definitely not a psychologist.
okay, you probably missed your calling. You might have missed your calling.
I could
so
be a
this
tech
part,
therapist.
actually, this part here is interesting. Okay. So yeah, go on, please. Yep.
Nicholas thinking at the time of the unaliving was characterized by the same features and factors that Nicholas thinking was always characterized by because he's autistic and because that's how he processes information. If Nicholas and his fixation on GB would have characterized everything that he did, and it would have colored everything that he did. I can't state whether that meets whatever criteria you guys are talking about, but I would say that with a lot of certainty, that was his preeminent thought at the time. Dr. W elaborated that Mr. Godejohn's thinking would have been on the things that were causing him the stress, and his focus would have been on the argument he was having with himself. Again, we can go back to the whole other issue.
We could have the argument that his penis was having with his head.
With the sandpaper.
That. Okay. Anyway, right, let's move on. So obviously Dr. W was cross-examined because everyone gets cross-examined. So on cross-examination, Dr. W testified that Mr. Godejohn is able to think, but all of his thoughts are colored and characterized by ASD. So GB initially brought up the idea of killing her mother in a joking manner, and she got progressively more serious about it. Okay, as you do. Yeah, it's funny. Let's kill her.
Yeah.
And Mr. Godejohn was against the idea. Important. He was against the idea to start off with. And I found this part really interesting, actually. He asked her many times if she was certain. About 1 year prior to the murder, Nick told a Facebook friend that he thought GB was crazy for wanting to kill her mum.
Well, he's not wrong.
Crazy. Yeah. This chick crazy, man. She's crazy. Mr. Godejohn justified the plan by bringing up how badly the victim treated GB. Yeah, well, I mean, she was horrible. About a month before the murder, Nick told a Facebook friend, "Me and the one I'm with are defying the laws of nature to stay together. It's as bad as can be. I won't tell you what I have to do to stay with her, but I will do it if it means keeping her."
Yes. And I think that was sent to a relative, not just a Facebook friend. I believe that was sent to a relative.
Ladies, find a man who loves you as much as Nick loves Gypsy.
Or one that is desperate enough for the P that he'll do this. One of the two.
This is the definition of a beta man, really. I mean, come on.
Yeah, women don't love men like this. This is just her exploiting his simpish behavior.
Wait, you mean she's going to throw him under the bus?
Oh, you think? How do you think this is going to turn out, eh?
I mean, he's still going to be sitting in prison no matter what happens. Even if he wins the appeal, his sentence probably isn't going to be shortened that much. Even if, best case scenario, he wins.
I mean,
it could be a lot. It could be down to 20 to life, eligible for parole in a fraction of the 20-year minimum. So no, it could make a big difference.
I think that's all that.
He's a young man, right?
Really?
Yeah.
He is. He's a young man.
He's 30 something now. I guess.
Yeah, he's 33 or something.
34, 35.
So
I think.
he gets out at 40 or 50. He's still got something of a life, right?
He's got a life that he can have a kid. You know.
Let's hope those genes don't get passed on.
Well. Oh, come on.
It wouldn't be his kid.
Well, that's true.
No, I mean, the kid would probably be.
He could have a puppy. Puppies are lovely. You know?
Oh, great. It can be an of mice and men situation.
No. Okay. Dr. W recalled Nick's statement that there was a moment when Nick stood outside the victim's bedroom door and something clicked and he realized he had given his word and was bound by it. Mr. Godejohn cut the back of the victim's neck so she would die quickly, and he briefly thought about having sex with the victim before deciding not to.
See? Good impulse control. That kind of hurts his appeal.
Kind of.
Oh, I hate that bit.
Yeah.
I hate that bit. I hate that bit so much. That just
So he knows right from wrong.
Yeah, like this again, we get back to the same problem here. Like he's able to have deliberation in his head. Like
Oh
Even-
God, Nick.
I
Just
think the
wanna
problem here is that he's
slap him.
screwed. Yeah, like
He's
I think he's screwed no matter what happens. Like I don't think that he's going to
screwed.
win this. I
Poor
really
dude.
don't.
I just want to slap him. Not in a
Yeah.
not in a violent way. Just like
Well-
in a come on, dude, wake up way.
Yeah, but he might like it.
Yeah, you might like it.
It's tough. Yeah.
Oh dear. Hey, Half Irish. What you got a question for Andrew?
Yes.
I was wondering if you consider just watching the Zachariah trial at your leisure from Veal's channel. You don't have to stream it if you're finding no time for it, but we'd appreciate your thoughts.
Yeah, but
Yeah.
that presumes that I have leisure time. I really don't have leisure time. So
Yeah.
the only way I could realistically justify expending the time at all would be to do it as a live stream.
Yeah, fair enough. Fair enough.
Yep.
Hey, Tilly, how are you? Good to see you, Tilly. You want Veal's link? Sure,
Mhm.
sure.
Yes. I'll get it.
Yep.
I have to
Mr.
do
Guy is
everything.
going to send it for you. No problem. It's good to see you, Tilly. Have a puppy. Oh, who's this? Hey, Diaz. Nice to see ya. Have a puppy. You mean some woman could have him as a puppy? It sounds like that's what he wanted all along.
Yeah.
Sounds like that. And hello, Fed. Good to see you, Fed. Nice to see you. G'day, Hella, Sal, Billhammer, and Branca. Yes. Oh, and hello. Who's this? Shifune. Have we had a raid or something? No, just someone saying hi. Good to see you, Laura Self Defense. What's this? Masaba gave you a shout out in
Oh,
his
yeah.
latest video. I don't know
No,
who
he's
that
a
is.
really knowledgeable guy.
Okay.
Yeah, he's really in the, like, I believe, self-defense area.
Okay, cool. Lovely. Alrighty, let's keep going. All right, so Dr. W testified that Nick described the argument in his head like having a devil on one shoulder and an angel on the other. Yeah, well, that's what Nick said. Yeah. However, it would be a mischaracterization to think they are two rational actors having a rational conversation. It was turmoil from the pressure of two competing sets of thought, and Mr. Godejohn would have described it as arguing because his vocabulary was limited. From the pressure between love and the general rules of society, Nick went back and forth and reached a point where he snapped. Dr. W would not characterize it as a conversation in Nick's head because it was more like pressure. Now, we're up to the plea offers.
Mhm.
People have asked a lot about this. So I'm keen to discuss it. People keep saying, oh, but wasn't he offered a plea? Why didn't he take a plea? And I had actually wondered whether or not he knew about Gypsy's plea. And it turns out he did. Okay, so the prosecutor stated at the post-conviction hearing that Mr. Godejohn was twice offered mitigated plea deals to plead guilty to murder in the second degree with a life sentence, and the prosecutor had taken mitigation into account when he extended those offers to Mr. Godejohn. The state believed that the case was prosecutable with deliberation, and the state would be able to overcome Dr. F's testimony if put to the test, but the state also believed that a just result could have been reached short of trial. Mr. Godejohn was open to a plea deal but rejected the specific offers because he was hoping for a sentence closer to the 10-year sentence that GB received. Wow.
I bet he was. I bet he was.
Wow.
And this is all perfectly normal, of course. You're offered a plea, so the state doesn't have to go to the trouble of a trial. If you make them go to the trouble of the trial, you don't get the plea offer.
Have you heard about the treehouse killing that's going on now? The guy is charged with unaliving or stabbing someone and being part of felony crime stealing where somebody died. He was given a 2-year plea or 2-year time served. He
Yeah, he coulda
refused
left.
because he couldn't confess to something he claims he didn't do. So he now is representing himself at trial and actually has a chance. Like, the evidence is so bad against him that there's a chance he could be found not guilty.
There's no evidence against him. That's the problem. The problem is the dude.
I really hope he's found not guilty.
Yeah, he's just so unlikable that it's like. But the thing is, this is the funny thing.
But why is he pro se?
Who knows? His wife's a millionaire.
Well, he's got
very good question.
He's been able to say a lot of stuff that maybe gets objected to,
yeah.
But he gets it out there that a actual lawyer wouldn't get away with.
Yeah.
So his trial strategy, he said that like his lawyer, being a member of the bar, could not use that strategy. But since he's not a member of the bar, not a lawyer, he could kind of play some games.
Yeah. And the thing is,
that's a high stakes game.
Yeah.
It's a very high stakes game. It's scary.
But
hey, Dina, how are you?
The prosecutor is actually terrified. Like the prosecutor was objecting like 10, 15 times in closing.
Yeah.
And just being treating him like a real lawyer.
Treehouse Man. Dina, we just changed topic for 5 seconds over to Treehouse Man.
Yeah.
We know you like Treehouse Man.
Yeah.
And Dina actually told Sean to change trials yesterday just to watch Treehouse Guy for a while.
Yesterday he testified, by the way.
Yeah.
He gave a narrative testimony and then was cross-examined, and in my opinion, humiliated the prosecutor.
Yeah.
Yeah.
He's doing surprisingly well for somebody who's pro se.
He's doing really well.
He's actually doing, I mean, he's making mistakes, obviously, and he doesn't know what things are called and stuff like that, but he's actually doing surprisingly well, even though he is kind of a douche.
Yeah.
He's more than a douche. He's quite a douche. He's quite a douche.
He's the whole bag.
He's the whole bag of douche. He's a bag full of douches.
It's a great trial.
Yeah. It's a great trial, and good call there, for future Mrs. Martin. Well done.
Yeah.
Because it was absolutely worth stopping the Troconis trial just for a minute to have Sean change tracks there. Anyway, cool. Beautiful explanation. Okay, keep going. So, Mr. Godejohn was open to a plea, but rejected the specific offer because he was hoping for a sentence closer to the 10-year sentence that Gypsy received. I thought that might have been the case. I thought he might have known that she got a 10-year sentence and was like, well, hang on, what are you doing giving me 30 when she's got 10? And all along, like, she was just as in on it with me. Like, she was there. Like, we were there together. And we both had the knife. And, like, she's the one who talked me into it. And, like, wait a minute, why? I don't get it. And I can just imagine the like, I know his brain's warped, right? Yeah. And in his mind, he would have been like, but this is not right. What's going on?
This is the part where he probably doesn't understand. Like he doesn't understand like what is happening. He probably doesn't understand how pleas work. But like he's still able to reason. He just doesn't understand. And if it's not fair, then like maybe he just turns into a child and throws a hissy fit. Like, but he still has the ability to reason. And he thought that they would be sympathetic to him, so he didn't take it. And when you do that, you're playing a big game, like like the other dude you're just talking about. You're playing a dangerous game. It's only your life, right?
Yeah.
That's true.
I mean, plea deals are the hardest conversations we have with clients as lawyers, because the clients often they want to tell their side. They maybe genuinely believe they didn't do anything wrong. Maybe they actually didn't do anything wrong.
Yeah,
maybe.
And but they're being prosecuted anyway. And the risk, of course, is that there's always somewhere between a 10% to 50% chance of getting convicted if we put you in front of a jury, no matter how innocent you are. And if you're looking at a serious time, 10, 20, 30 years, life in prison, and you're offered something like time served, of course, it's a conviction. Of course, it dooms you for any civil liability that might exist in the case, because if you plead guilty to the crime, you're basically pleading at fault for the civil litigation. But maybe that's, that takes off the table the potential of decades or life in prison. And a lot of clients don't want to take the deal, and you have to, they get to decide. You can't make them take it, but you tell them what the reality is and tell them to go speak to their family and friends about it and come back in a couple days. And, don't just throw this out the window because it feels uncomfortable.
Yeah. I mean,
time served.
especially if someone has actually not done something.
Yeah.
If they really feel like, especially if what's being offered is far more than they've done. Like if they are being charged with, or the plea is like first degree, for example, and in their mind, it was manslaughter.
Yeah.
Or the plea deal is second degree, whatever it was. It's far higher in their minds than they think that they are responsible for or culpable for. And it's like, well, hang on, but that's not what I did. Yet it's better than they're going to actually be convicted for if they go to trial.
I mean, that's actually the easier scenario, right? They know they did something. They know they killed somebody. They just disagree about the degree of the killing, right? How much of an unlawful killing it was. The hardest conversations are with the clients who either they just genuinely believe they didn't do anything wrong, or they didn't do anything wrong. And the truth is, none of us know, right? None of us were there when this event happened. We're just looking at evidence and hearing stories and trying to come to some facsimile of truth. But the system's not really about truth. Everyone understands there is no absolute truth that's knowable to us. We're convicting people by the tens of thousands every day without absolute truth. That's not what the law requires. It requires proof beyond a reasonable doubt, but doubt is permissible. So you never know for sure whether you're guilty of the crime or not. And the system's not about fairness. It's a bureaucratic administrative system. We call it the criminal justice system. But the most powerful word in that phrase is the word system. It's a machine. It doesn't actually care about truth. And the second most powerful word in criminal justice system is criminal. It's a system designed for criminals. It's optimized for criminals. It doesn't do very well when dealing with people who are not actually criminals. And then you have justice as the third most important word.
Exactly.
And that doesn't mean fairness. That means, everyone's subject to the same due process of law. It doesn't mean you necessarily have a fair outcome.
All right. So at the conclusion of the evidentiary hearing, the motion court announced, I'm sort of like, the court actually said this, that I'm sort of like Nicholas. I do better reading than listening. If I may suggest that you give me written suggestions if you wish to do so.
Okay.
The judgment held that Mr. Godejohn failed to demonstrate that counsel's performance was deficient in the strategic choice of Dr. F over another expert who may have testified more favorably. The judgment cited case law holding that the selection of witnesses is unchallengeable trial strategy, and defense counsel is not obligated to shop for an expert witness who might provide more favorable testimony. Mr. Godejohn timely filed his notice of appeal on March 24, 2023, and this appeal follows. So that's kind of where we're at. Not really much more. Oh, yeah, there's just one. Okay, so the motion court clearly erred in denying Mr. Godejohn's Rule 29.5 motion because a review of the record leaves a definite and firm impression that he was denied effective assistance of counsel as guaranteed by the 6th and 14th Amendments of the United States Constitution and Article 1, 18A of the Missouri Constitution, in that trial counsel failed to act as reasonably competent attorney under the same or similar circumstances by failing to fully investigate and present evidence from a qualified neuropsychologist specializing in autism spectrum disorder to support the diminished capacity defense.
I have a question.
Yeah.
Is this like your standard basically appeal for ineffective counsel? Is basically
99.99% of them look like this.
Okay.
To my eye, it's the appearances going through the motions.
Yeah. Okay.
I assume so, but I don't look at these on a regular basis.
I mean, there are legitimate ones, of course, and the ones that tend to hold water are where the lawyer just missed deadlines for filing.
How is that
arguments or papers or evidence that would have been relevant to a jury in considering guilt, or when a defendant was unable to communicate with their lawyer, like the lawyer couldn't get them on the phone for extended periods of time.
Appeals handled, like, is that considered ineffective? Do they get a new trial?
Typically, they'd get a new trial. Right.
If
It would
the
be
lawyer misses
remanded
things.
back to the
Okay.
trial court with new legal counsel.
Okay.
But that's an infinitesimal percentage of these ineffective assistance claims.
Yeah.
They're argued all the time. They fail all the time. That should be the expectation.
Yeah.
Well, David is starting up his stream now, so we are going to head
thought in
all the
15
way over
minutes.
there. No, he has started amazingly. I thought it was supposed to be 15 minutes away, but no. So we are going to raid the bejesus out of it. He's got his opening street thing on now. On it. Oh yeah, he does. He's got it on. So I don't want anyone to miss a second of that. The Sadie Beecham interrogation. I'm a little scared to watch it, but yep, let's go and support it, guys. So free Zachariah Anderson. Everyone's going to be over there. Tomorrow, really important, we have Fancy Michelli, who's going to be our special guest, and it's a series finale for our Gypsy Rose content. And then we will, in some capacity, be covering the Murdoch juror questioning on Friday, and in some capacity be covering the Koberger hearing as well. So, guys, hang on tight. I'm dumping you over into the MLS channel now. Stay with us and then go EU raid over there. See you guys.
Bye-bye.
Bye.
Thanks, Andrew.
Bye. Hang on. Let me just thank you, Andrew, for being here.
Oh.
Love you very much. Okay, bye. Oh God, hang on. And extreme.
Reach around.
Can we start
Reach
saying your
around.